It is still not worthy of passage through this House.
David Cleandon.
Thank you, Mr Speaker. One would be hard-pressed to say it's a pleasure to speak to this bill. It's more a matter of being resigned to having to speak in opposition to this raft of justice legislation that comes from this government, most of it poorly thought out, and it will not deliver the results or the outcomes that they're intended to produce. Sir, I didn't have the... I will say something nice, just to please Mr Williamson. I wasn't sitting on the Select Committee for this bill. I do have to commend the Select Committee that this bill is significantly better, or should I say less bad, than it was going into the committee. And I'll speak in some detail of some of the clauses that were in the original, or some of the provisions in the original drafting that are frankly a disgrace. And the Minister should have been ashamed to put her name to some of those draft provisions. I'll come to that in time. One of the first things one notices reading the Select Committee report on this bill is the intention or the proposal to change the name of the bill from the Legal Assistance Sustainability Amendment Bill to the Legal Assistance Bill. I guess I'd say good try, folks, but I think you can't really deny the fact that nevertheless this bill is about cost cutting. So as a student, practitioner, researcher and teacher of resource management, I know a bit about sustainability, and often in the language of sustainability you're talking about resource allocation, and particularly the allocation of scarce resource. And the scarce resource we're talking about here under this government is access to justice, which is becoming increasingly scarce in this country with the array of legislation that we're seeing put into place. Misguided policy and the family court proceedings is another very good example, or rather very poor example of that. So I'm afraid nobody will be persuaded by the change of name or the change of some elements of the bill that this is anything but a cost-cutting exercise. The government doesn't seem to have woken up to the fact that the line-by-line budget reduction they're imposing on their ministers, the obligation to snip away at every single line item, is actually a flawed and a doomed process. Any business owner or any successful business owner knows that if you try to cut every line item in your budget without thought to the consequence, without thought to the cumulative effect, then very quickly you will find yourself in a condition of failure. This bill will not reduce costs overall to the government, to the state, to the justice system. It will simply displace costs into other parts of that system, and on the way it will also impose significant social costs, which will be borne by some of the most vulnerable, by some of the least able to bear those costs. So that point was very well made in terms of by the judges from the Wellington District Courts, who very carefully prefaced their comments, recognising that the judiciary and Parliament stand in a relationship of tension. They were not taking a political stance, simply a pragmatic one. And they pointed out, and I quote, that formal legal proceedings, the point they're making is that driving down access to justice for individuals, taking away the opportunity for people to get legal representation, will lead to more self-representation in the court. More self-litigants will endeavour, typically quite badly, to represent themselves in the courts because they can't afford to pay a lawyer and legal aid will not be available to them. What did the Wellington District Court judges have to say about that? They said formal legal proceedings in which parties represent themselves often take significantly longer than they would if counsel were appointed, and require judges to take a proactive role in assisting the undefended party. They make the point that it's often necessary to appoint a friend of the court, an amicus curiae, if my Latin pronunciation stays with me. And that simply puts costs on the court's budgets rather than some other place. The district courts, they go on to say, the judges go on to say, are concerned that any savings made by restricting access to legal aid in summary criminal matters may be offset by an increase in the number of self-represented litigants, putting pressure on court time and resources. They go on to say that self-litigant, self-representation also puts extra load on court staff who experience difficulty in communicating, getting information to people who may be itinerant, who may not have a fixed address, who may have poor literacy skills. and they are constantly having to explain matters. Instead of being able to speak a convenient legal shorthand as they can with legal representation, they're obliged to spell it out. All this bill does, and so many others, is displace cost and the misguided attempt to reduce it. We saw several, there were numerous submissions to this bill, as there have been from others, from the legal fraternity, from the profession, from the Law Society, from the Criminal Bar Association, from individual lawyers, from community law centres and the like. And unfortunately, the constant refrain we hear from this government, and indeed from the Minister, is that the lawyers are simply displaying self-interest. And that's a very unreasonable and an unwarranted claim that lawyers are simply self-interested. Mr Little commented on some of the conversations he's had with lawyers and legal firms. I've had very similar conversations as recently as last night with people who are saying that many legal practices now will actually not go there with legal aid cases because they simply can't afford to bear the loss, to bear the cost that it imposes on them. And it's interesting, the Criminal Bar Association, in their supplementary submission, they referenced the Baisley report and pointed out that it recommended that criminal lawyers operate a proper business infrastructure, that they deliver a high quality of service to their clients and to the courts and indeed to the justice system, that competency and seniority be properly remunerated. These are absolute obligations that any ethical legal firm or any legal practitioner professing to have an ethical basis for their practice must accept that there is cost to delivering these services. And the bottom line is that if the legal aid provision is not sufficient to meet those costs, then there is a limit to their capacity to operate ethically and properly and in a way that will fulfil their obligation. So we have heard a great deal about, as I've said, there's a great deal to criticise in this bill even now. I do have to acknowledge that there were some considerable improvements made. One of them was the so-called Henry VIII provision that in the initial drafting would have allowed the Minister effectively, by order in council, to determine eligibility and to vary eligibility over time, according, and I think the phrase was something about maintaining the viability of the whole system. Now, yes, it does need to be viable, but Henry VIII clauses, as we know, are anathema. We don't want the ability given to ministers of any colour or of any government to make substantive alterations to legislation. That is Parliament's job and not a minister's, or not by order in council. The Henry VIII clause was refused. I think one of the most disgraceful elements of the first draft of this bill, and again I give credit to the Select Committee for having amended that this be taken out, is around the matter of disposable capital. In the original drafting, it was proposed that a person's capacity to pay for their own legal representation should in part be determined by an assessment of their disposable capital, their disposable assets, such things as people's furnishings, their clothing, their tools of trade, technologies, assistive technologies for people with disabilities. In other words, under the original draft, before one could claim legal aid, you might have to sell your sofa and your kitchen table, your clothing, the tools which you use to make a living, your hearing aid. What an extraordinary and a disgraceful proposition, and all credit to the Select Committee for having thrown that one out. And I hope we don't see anything of that ilk reappear in any other legislation. Similarly, the proposition that there should be changes to the appointment processes for youth advocates. The youth court judges came out very strongly and essentially said, this is not broken, don't fix it. The process works very well. The youth court advocates do a very good job. It's a very difficult job. They are well qualified. They meet a very high bar before they can be recognised and perform in that role. And let's not try and mend something that isn't broken. So I'd like to just very briefly comment too that a number of submitters pointed out that the overall thrust of this bill, by making access to justice less readily available to the least well off, is actually at odds with our Bill of Rights Act. The right to consult and instruct a lawyer is embedded. I'll look forward to continuing this conversation in later readings. For now, suffice to say, the Greens will oppose this legislation.
I call Alfred Naro.